morning, my lord, my lady, my lords, my lady. My lord, I summarised yesterday our three core submissions, and I will take each of them in turn this morning. Professor Webb will then briefly address the court specifically on the range of respects in which, aside from Article 11, the State Immunity Act and the European Convention on State Immunity diverge, and Mr Silverstone will address the Human Rights Act argument. Before addressing those three core submissions in turn, I'd like, if I may, also just to emphasise at the outset what we respectfully submit to be three central and recurring flaws in Bahrain's case. Firstly, it is Bahrain's case, not ours, which requires the reading of words into Section 5 of the State Immunity Act. It either seeks to read in a presence requirement, or it seeks to read in and introduce an element of exclusivity requiring all acts to have occurred in the United Kingdom, or it seeks to introduce a concept of initiating act into the wording used. Secondly, as I summarised yesterday, it wrongly treats the Court of Appeal's interpretation as leading to the conclusion that the United Kingdom would be in breach of the European Convention on State Immunity. It does not, because of the divergence permitted by Article 24. And thirdly, again, as I submitted yesterday, it proceeds from the wrong starting point in international law. The correct starting point in international law is that a state is entitled to immunity in respect of some, but not all, sovereign acts. And customary international law does not require the grant of immunity in relation to all sovereign acts occurring in the forum state and causative of personal injury.
Sorry, could you just repeat the third?
The third one, my lord, yes. It proceeds from the wrong starting point in international law.
Yes.
The correct starting point in international law is that a state is entitled to immunity in respect of some, but not all, sovereign acts. And customary international law does not require the grant of immunity in relation to all sovereign acts occurring in the forum state and causative of personal injury. So, against that background, my lords, my lady, core submission 1, the natural and ordinary meaning of the words used in Section 5, read in their statutory context. We make 5 points in respect of this submission. Firstly, the correct approach on the authorities is to have primary regard to the section in issue and to what is called in the authorities the statutory context. That is the part of an act that the section is located in and the act itself. There is nothing objectionable in taking the natural and ordinary meaning of the words used in their statutory context first, before considering the implications, if any, of international law. Secondly, we say that the words actually used in Section 5 and that statutory context point in favour of the Court of Appeal's interpretation in a number of respects, having regard to the State Immunity Act's long title, to the repeated emphasis on territorial connection underpinning the exceptions to immunity, and to the fact that when Parliament intended to make presence a significant factor, it did so in express terms. Thirdly, it is the appellant's two alternative interpretations as articulated.
Are you going to develop that point later?
I am.
Yeah.
Yes, I'll take you to each of the sections. It's the third point in summary is that it's the appellant's two alternative interpretations of Section 5, which involve the impermissible reading of words into the section, not the Court of Appeal's approach, which instead simply adopts and applies their straightforward meaning. One of the key errors that I've already sought to identify. Fourthly, it is the appellant's approach which would give rise to inconsistency and incoherence rather than the Court of Appeals. And it certainly cannot be said that the Court of Appeal's approach would give rise to absurdity, which we say would be the high bar that would need to be cleared to displace what we submit to be the clear, unambiguous words used. And fifthly, we say the appellant gains no material support for its approach from either domestic or comparative case law, or from academic materials, or inadmissible, unpublished ministerial notes. So on the first of those points, the first criticism that you will have seen in the appellant's case of the Court of Appeal is that it took the wrong starting point, and it took the wrong starting point in focusing on the natural and ordinary meaning of the words used in Section 5, and it should instead have looked first at the European Convention on State Immunity and its relationship with the Act, and they cite the authority of Packard and Lord Sales that you've seen for that proposition. Now,
It can't really matter which order you do things in, as long as you do both, I would.
that's, with respect, my point, my Lord. It's ultimately a mechanistic, unfair criticism. And we see that, I don't need to turn it up, I don't think, but we see that from Packard itself, where Lord Sales actually starts his analysis in the end with what the ordinary meaning of the words is. And he explains that the primary means, this is in the very next paragraph to that cited by my learned friend, at paragraph 42 of his judgment, the primary means by which Parliament's meaning is to be ascertained is the section, the group of sections, and the statute as a whole. And that's not to say that you don't look at the international law consequences and the international law consistency or otherwise. I entirely accept that. But there's nothing wrong with that starting point. It's an entirely conventional and sensible one. It's also a principled one for sound constitutional reasons, for the reasons explained by this court, Lord Hodge in particular in O, as cited by the Court of Appeal in its judgment in these proceedings at paragraph 20. Citizens, and one can extend that to any subjects, and their advisers are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. And they should be able to rely upon what they read in an Act of Parliament for that purpose. An entirely unsurprising starting point, therefore. But we entirely accept what my Lord Lloyd Jones said in General Dynamics in the context of State Immunity Act, and the reference for this is paragraph 39 of His Lordship's judgment at page 885 of the authorities bundle, where your Lordship was considering the right approach to interpretation of section 12 of the Act, and your Lordship said, the scope of section 12 is to be decided having regard to the ordinary meaning of the statutory provision, its purpose and its legal context, including considerations of international law and comity. So they all need to be considered. It doesn't really matter what order you do it in. And we say the Court of Appeal had entirely proper regard to all of these matters. It set out this court's description of the background to the Act from the Argentum judgment and the Act's full title at paragraphs 18 and 19. It set out the key principles. This is in the core bundle at 148, if your Lordships and my lady would like to see it, have the Court of Appeal's judgment before you. It set out the key principles of statutory interpretation with the citation of Lord Hodge in O at paragraph 20. It considered the ordinary language used in section 5 at 21, 23 and 54. He considered wider principles of international law at paragraph 22, 40 and 55, emphasising, we say, in an appropriate way, which Bahrain's case fundamentally avoids, the critical importance of territorial sovereignty in international law. And it considered the broad aim of the State Immunity Act and the impact of the European Convention on State Immunity, and particularly Article 11, in responding to the submissions advanced to it, paragraphs 51 and 57 to 64. So that first criticism of the Court of Appeal is we submit, an unfair and mechanistic one, which on analysis is empty. What matters then, first of all, and of course I will come to EWCA and international law more broadly, but what matters first of all is then Section 5 and its statutory context, what the reader of the Act itself would understand is being covered here. And it's perhaps useful, albeit it'll be very familiar, but it's perhaps useful again just to have regard to the judgment of the Court of Appeal in that regard, to look at Section 5 and its wording alongside the interpretation actually identified by the Court of Appeal. Now, the wording, of course, is paragraph 7, top of page 144 of the bundle. State is not immune as respects proceedings in respect of personal injury caused by an act or omission in the United Kingdom. And then if we look at the interpretation of those words arrived at by the Court of Appeal, which is said to be flawed in this case, you have that at paragraph 54. I agree, this is Lord Justice Males, I agree with the judge that the language of Section 5 is clear and unambiguous. A foreign state does not have immunity for personal injury caused by an act in the United Kingdom, even if other causative acts take place abroad. It is, we submit, as simple and straightforward as that. Now,
well, it's not as simple and straightforward as that, because the question is, has there been an act in the United Kingdom here? And it seems pretty obvious to me, but obviously other people take a different view, that there hasn't. The only act has been in Bahrain, where the person, because the only place you can do an act is where you are, not some place the other side of the world. I can't do acts there, so it seems to me, but obviously it doesn't seem that way to Lord Justice Males, so I probably have to accept that it's ambiguous. But well, if it wasn't for that, I'd say it was unambiguous against you.
Well, my Lord, I discerned your Lordship's provisional position yesterday.
It's a feature of language that people do. You know, what one person's ambiguity is, another's clear and unequivocal.
My response to it at this stage of the argument, my Lord, is I well understand that the point you've just put to me, and indeed the point that my Lord Burrows put to me yesterday and raised in argument when looking at Clark and Lindsell, require careful consideration as to whether an act in the United Kingdom has occurred. And that is the battle I'll have to confront under my core submission 3. What I'm looking at the moment is the first question, how you interpret the act. And on how you interpret the act, we say the words used, albeit in a different context by Lord Bingham in Jones, plain as plain can be, are entirely apt here. What you're looking for is a causative act in the United Kingdom.
Yeah.
You're not looking for presence. You're not looking for all the causative acts. You're not looking for an initiating act. What you're looking for is a single causative act in the United Kingdom. So I see, you're just taking the first step of the argument. Exactly. I entirely acknowledge that I may fail on this appeal, at least so far as your Lordship's position is concerned, if I can't make some headway on core submission 3 in response to my...
See, you're just saying you can't try and bring in some other act that isn't the act relied on, you know, some previous act.
You don't...
Or some There has to be an act in the
There has to be
United
an act. You don't need...
No.
If you've got a causative act, you don't need to bring in other acts,
No.
and it doesn't prevent you from satisfying Section 5 that there are other acts. And the Litvinenko example is a good example of that, or the political assassination case is a good example of that, because you will obviously have other acts outside the jurisdiction in terms of the planning, the provision of poison, the provision of facilities to the agents travelling abroad, which, in an ideal world, you might wish to bring before the court, but you don't need to.
No. Well, whether you need to or not, I don't know, but you can't anyway.
Yes, my lord. You don't need to for the purposes of establishing on our analysis the cause of action. So that's what we say about that, my lord. We do say, with respect, that at this stage of the argument, in terms of interpretation, it is plain as plain can be, albeit I recognise the hurdle that's been identified for core submission 3.
I'm not sure you can dissociate the two at this moment in time, because we're talking about ambiguity in the context in which we're actually dealing with the issue. But anyway, I find it difficult to separate the two. But you're just saying, well, you need an act in the United Kingdom, a causative act in the United Kingdom, and that's all you're saying at this moment in time.
Yes, my lord. And
You're not relating that to the facts of our case?
No.
Okay. Right.
And I get quite a long way in establishing that proposition on the bare terms of the act.
Yes.
I say.
It's just when you've got to apply it, well, I think we're going to have more difficulty. But
I
anyway,
understand that, my lord, and that's why I answered my Lord Legate in the way that I did.
Well, no doubt we'll come to that.
We'll come to that.
Stage 3 of your submission.
I'm now on double notice of the hurdles these days. But on our interpretation, this first stage, there's no gloss at all being applied to the plain words used. It is plain as plain can be. There's no room at all for introducing the words that Bahrain would like to introduce, and it would be a particularly striking illustration of inappropriate statutory interpretation when, as my lady pointed out yesterday, I think, in her observations to Mr Hickman, Parliament actually had Article 11 before it. It had been written 6 years before when it came to enact the State Immunity Act. If it had wanted to introduce a presence requirement, it could and would have done so. So that's obviously only part of this, but it's a very important starting point on the question of interpretation. Look at the section itself. Does the Court of Appeal's interpretation involve any gloss at all, any introduction of words? No, it doesn't.
can I just ask you, I mean, my understanding is that the first instance judge introduced a de minimis requirement. Now, is this are we at this stage of the argument, or is that coming later?
No, my lord, I'll deal with that at this stage of the argument, because it's said that it's...
And it might be said that the Court of Appeal have done something similar by the words "in essence."
What the Court of Appeal have done, my lord, and what we say on a fair reading, all Mr Justice Knowles has done, is require the Act to be causative in law. Not peripheral, not too remote, more than de minimis, another way of putting it. There's no indication anywhere that either Mr Justice Knowles or the Court of Appeal had any regard to the industrial disease cases that Mr Hickman contends that they inappropriately borrowed from.
It's just rather odd. If all he means is it has to be a legally effective cause, I've never heard the words de minimis used in that context.
But the Court of Appeal didn't use those words.
The Court of Appeal used the word causative act
Yeah.
at paragraph 54, and we say that's what both of them were getting at. This is a point we've sought to answer from my Lord Borough's reference at paragraph 26 of our case. We say what Mr Justice Knowles and the Court of Appeal were doing was no more than make the obvious point, consistent again with the plain words of the statute, that the Act had to be causative in law to qualify. If it was too remote, if it was too peripheral, it wouldn't. So we do say...
Sorry, when I say the Court of Appeal, I'm looking at paragraph 37.
Yes, my lord. Paragraph 37, my
The
lord.
essence of what agents are alleged. The essence.
Yes,
of
my
what
lord, and
alleged done.
Again, without wishing to retreat again from a battle I know I'm going to have to fight, this paragraph 37 is under the heading, ground one, was there an act by the foreign state in the United Kingdom?
Right.
And so it's not on the, it's not,
On the test, it's on the application.
it's on the application, it's not on the interpretation.
All right.
And what's material on the interpretation, my lord, is paragraph 54, which is the very simple, and we say with respect entirely accurate formulation, an act in the United Kingdom. A foreign state does not have immunity for personal injury caused by an act in the United Kingdom, even if other causative acts take place abroad. That's it.
I suppose I'm saying, look, this is not important. We're all accepting it's got to be an act in the UK. It's a question of what that means in this case. But
It's
anyway,
a question of how you apply it in this, but we're not all accepting that, my lord, because what Mr. Hickman says is you've got to read a presence requirement into Section 5. And what Mr. Hickman says is you've got to read in all the causative acts into Section 5.
Or the precipitation.
Or the initiating act into Section 5. So I'd be
or
delighted if those in
precipitating.
front of me are all of that view. Those to my right are certainly not, and that's why I'm addressing it, my lord. Now,
You said that there were examples of provisions in the Act that
Yes, I was going to
Parliament
go to
had
that.
chosen to deal with.
yes, well, that is,
That's your next point, I think, is it?
Is it?
that's my next point, is to look at the scheme of the Act as opposed to simply the section. And so if you go to the Act itself, you have it in its pre-Benkebouche form, which is fine for these purposes, at 2121. And you have the long title of the Act, which is itself set out by the Court of Appeal at paragraph 9.
Sorry, could you bear with me just a moment?
Yes, Mark.
Technical problem. Yes, sorry about that.
Thank you, my lord. 2121, you have the long title of the Act, as I say, referred to by the Court of Appeal at paragraph 19. It refers, of course, to the European Convention on State Immunity. It doesn't refer to the European Convention on State Immunity's approach to immunity and to the exceptions in Articles 1 to 13 at all. It only refers to the European Convention in the second clause, stating that it's to provide for the effect of judgments given against the United Kingdom in the courts of states parties to the Convention. And so far as immunity is concerned, it states only the Act intends to make new provision. So that's the starting point, and I'm not avoiding compatibility with EWCA, which I'll come to, but that's a relevant factor to have in mind, we say. Secondly, the whole scheme of the Act is, we say, replete with reference to and the significance of the question of territorial connection, of one kind or another being sufficient to displace immunity. We see that in section 3(1)(b). State is not immune as respects proceedings relating to an obligation of the state which, by virtue of a contract, falls to be performed wholly or partly in the United Kingdom. We see it in section 4(1), contracts of employment, again, where the work is to be wholly or partly performed in the United Kingdom. Section 6, ownership, possession and use of property. 6(1). Section 7, patents registered or protected in the United Kingdom. And 8, membership of bodies incorporated under the law of the United Kingdom. Now, all of them indicating that territorial connection is important.
Well, it obviously is in our section 2. I mean, there's no doubt about that. You've got to have an act in the United Kingdom.
Yes, my lord.
Not sure it tells you when there is an act in the United Kingdom.
Well, that's where we'll come to my artificial and see if I can do better than that adjective later. But it's emphasising, entirely unsurprisingly, the significance, both in the domestic statute, consistent with international law, of territorial sovereignty and territorial connection as a displacer of immunity. Now, the presence issue that I mentioned earlier, the only other area where we get presence dealt with is in, as I stand to be corrected, I think, is in section 16.2 of the Act, where presence features for a slightly different purpose, but it's making it explicit that the Act, this part of the Act, does not apply in relation to anything done by or in relation to the armed forces of a state while present in the United Kingdom. So that, coupled with the fact that Article 11 was before it, again indicates Parliament didn't see it appropriate to introduce a presence requirement into Section 5. Now, none of these points are knockouts, of course, but they all, we say, go in the same general direction. And the underlying point, when one's pausing here at this stage of the analysis, is that we say there's no ambiguity on the face of Section 5, and there's nothing to create ambiguity when you look at the remainder of the sections and the overall scheme of the Act. There's nothing to indicate that the words used are anything other than as set out by the Court of Appeal in paragraph 54. And we then look instead, and I've previewed this already, so I'll take it quite quickly. We then look at the appellant's suggested alternative interpretations of Section 5. Before the Court of Appeal, only one alternative was proposed, and it's that set out at paragraph 51 of the judgment of the Court of Appeal at Core Bundle 157, that Section 5 was to be interpreted as meaning that the exception to immunity applied only if all the acts causing personal injury occurred in the United Kingdom. And this at a stage, as my Lord Hamlin observed yesterday, at a stage when Bahrain's position was that a Litvinenko scenario would be immune. And so Bahrain was saying then, well, no, you can't get home here because planning must have occurred essentially outside the United Kingdom. Now, this is now at least sequentially downgraded to being the second of the interpretations contended for by Bahrain on this appeal. It's set out by them in their case at 61 to 68, with particular reliance placed, at least in writing, although we didn't hear about it yesterday, on the potential for the singular to embrace the plural as a result of the Interpretation Act. And we answer this at paragraph 31 of our case at Core Bundle 110. And as we point out there, this interpretation involves a straightforward, and we would say therefore impermissible, rewriting of Section 5. In particular, it introduces the notion of exclusivity that I referred to earlier. It requires the section to say a state is not immune in respect of proceedings for personal injury caused only by an act or omission or acts or omissions in the United Kingdom. Now, the Interpretation Act would do the work of getting you from singular to plural, but it wouldn't do the work of injecting exclusivity into Section 5.
I'm not sure how the interpretation is meant to work unless the section is limited to acts which are necessary to establish your cause of action. I mean, why should you have to show that some other acts, that there were no other acts that caused the event, if they're not relied on as part of your cause of action?
It may be that the reason it's been downgraded to second line of attack is because the Litvinenko argument has been abandoned by Bahrain in this appeal, because one can see why it was necessary for their case when that was still a live issue. we say, and again, this will necessarily takes me to core submission 3, we say that all acts, in fact, necessary for us to establish our cause of action in this case, or a sufficient number of acts.
Well, you only need one, really,
Well,
for a cause, or maybe you need more for,
might need
for
more.
harassment, I suppose.
Exactly.
You need a course of conduct.
Course of conduct. But we say we've got
Anyway, enough.
plenty of that, exactly. So that's alternative submission 1 or 2, however one puts it. If Parliament had wished to achieve that exclusivity, something akin to the entire tort doctrine in the United States, for example, it could have done so. And it wouldn't have used the indefinite article that it did in Section 5. Instead, of course, it only required an act causative of personal injury. Now, the other interpretation contended for by Bahrain is that set out at 49 to 60 of its case, where it's contended the words an act in Section 5 must be read as meaning the responsible or precipitating act. That's how it's put in the heading to that section.
It's been
And we addressed this.
It's being expressed in various different ways yesterday. Responsible, precipitating,
Initiating.
Yes,
Yes,
the
Mark.
other one. Yes.
All of them involve writing words in that aren't there. We seek to make that point at paragraphs 24 to 30 of our case, at 109 to 10 of the bundle. And again, if it's remotely helpful, we've done the sort of strike through underlining illustration of the amendments that would be involved at paragraph 27 of our case. Now, for these purposes, in their written case, the appellant starts by contending that the Court of Appeal and the judge failed to give sufficient emphasis to Section 5 as a whole, and in particular to the words caused by. We again say that's an unfair and flawed criticism of the Court of Appeal. What the Court of Appeal and the judge each did was to look carefully at the section, attribute significance to the indefinite article preceding act in Section 5, and directly take into account the words caused by the emphasis on causative act, paragraph 54, or on my characterisation of it, the reference to de minimis in Mr. Justice Knowles. But it's obviously the Court of Appeal that matters, really, for my purposes.
Well, it would be odd if the Act applied a different test of causation from the law of tort that the Act is reflecting.
Yes, and the law of tort does not require or contemplate that there will only be one causative act capable of giving rise to a cause of action. And then and the same goes for the further formulation of initiating act. And we say that the fact that one has to consider interpolation and addition in this way only illustrates the impermissible nature of the exercise being engaged in. And we make the point about what the law of tort ordinarily requires by at paragraph 26 of our case, where we emphasise the Clark and Lindsall passages, showing that the ultimate policy question the court is asking in terms of causation is to determine what damage the defendant should be held responsible for. Now, I appreciate I'll have to come back to paragraph 2.01 of Clark and Lindsall in light of Lord Borough's intervention yesterday under Core Submission 3, but asking that question and answering that question, it's not a difficult one in this case. We say the defendant, Bahrain, should be held responsible for infiltrating the respondent's computers situated in the United Kingdom. extracting information from those computers situated in the United Kingdom, intercepting communications in the United Kingdom, recording audio and video in the United Kingdom. And so to take the exercise that Mr. Hickman said yesterday was appropriate, of starting with the harm and then going back in the chain to see where you needed to get to before you allocated responsibility, you don't need to go very far, we say, because the harm flows from all of those UK-centred acts, as are...
Well, that is where the debate comes.
Exactly, exactly, Mark. But none of that applies, we say, at this stage of the argument. What's the correct interpretation of Section 5? Now, incoherence, inconsistency, and absurdity, we say there's nothing incoherent or inconsistent, let alone absurd, in the Court of Appeal's approach and its interpretation. And we set out our case in that regard in the written case at 32 to 37. We say what the interpretation does achieve is an entirely principled outcome identified at paragraph 55 of the Court of Appeal's judgment. If State A interferes with the territorial sovereignty of State B by doing an act in State B which causes personal injury, it takes the risk that it will be subject to civil proceedings and lose adjudicative immunity. And that is consistent with the fundamental principles on which state immunity is based, which the Court of Appeal emphasised in its judgment at 18 through to 22, and which I'll come on to when dealing with the international law position. And it's not a problem, it's not a burden I need to take on to say, is the landing point of Article 11 principled or incoherent, or would it give rise to problems or not? It's a particular position. The question that I need to grapple with, and the material question for the court, is instead whether the interpretation which we say flows from the words used, from the statute itself, the other sections and so forth, itself give rise to such incoherence and inconsistency of approach that it has to be displaced. And we say it just doesn't. On the contrary, it is firmly anchored in a principle which is reflected right through the State Immunity Act and entirely consistent with it, that of territorial sovereignty. That leaves only on this first core submission. I'll deal obviously with international law position separately under my second core submission, but only on this first core submission, the proposition as we advance it, namely that the appellant gains no material support for its approach from domestic or comparative case law, from academic commentary, or from the ministerial notes. And so far as domestic authority is concerned, the appellant referred in its written case, although yesterday in rather more modest terms, to the case of Heiser as providing it with some support. We explain why it doesn't provide any such support at paragraphs 38 to 41 of our written case. And as the court noted yesterday, Lord Hamlin noted yesterday, the judge there in fact gave no decision on what might be termed a purer composite act theory relating to the question whether, for example, the firing of a missile from country A into country B constituted an act in both countries. He didn't decide that. And again, as was pointed out, I think, by my Lord Burrows yesterday, at paragraphs 150 and 152 of Heiser, the judge emphasised that the State Immunity Act did not replicate the European Convention on State Immunity, and instead he highlighted the fact that, particularly focusing on Section 5 and Article 11, the former contained no presence requirement. So that's Heiser. No other domestic case law is cited. We've referred in our written case to Jones and Al-Adsani and the description in that context of Section 5 as being plain as plain can be, for what it's worth, albeit, of course, they were addressing a different question so far as Section 5 was concerned. So far as comparative case law is concerned, Mr. Hickman referred understandably yesterday to Kidane from the United States and similar cases from the United States, and Kazemi from Canada. We've addressed Kidane and the other US case law in our written case at 67 to 73, and the Court of Appeal addressed it at 76 to 80 of its judgment in the core bundle at 164. In essence, we say it provides no material assistance for the reasons we've given there. It concerns a differently worded statute and a doctrine, the entire tort doctrine, which Bahrain acknowledged before the Court of Appeal is not part of English law. Now, it is true, as I think my Lord Legate observed yesterday, or perhaps it was my Lord Jones, or both, United States legislation is wider on its bare terms in the sense that it refers to injury occurring in the United States. But it is also narrower, we say, in a significant regard, because it requires an inquiry into the, emphasising the definite article, tortious act. So it doesn't mirror the Section 5 approach here, and one can see how that language could give life to an entire tort doctrine or a cousin of it in a way that Section 5 doesn't. The reference in the bundle to the US statute is 2911. The only other comparative case law referenced by Bahrain is, as I said, Kazemi, and it's addressed by them in their printed case at 106 to 107 and by us in ours at 74.
Is that the Ethiopian case? No.
No, it's the
Kidane was the
No,
Ethiopian.
Canadian case. The
Canadian.
it's Iran.
It's Iran, sorry.
Isn't it?
Yes.
Yes. So Kazemi is addressed in our written case at 74 to 76. And turn up, if I may, what we've said there. My ladies and my lords, right, the case didn't involve any allegations of conduct in Canada at all. It concerned the torture and death of a Canadian citizen in Iran. The case again concerned a differently worded statute, and one of the key statements of principle that you weren't taken to yesterday, but that we do rely upon, is paragraph 72 of the judgment that we've quoted at paragraph 76 of our case, but it's perhaps worth turning it up. It's 2769 of the authorities bundle. Paragraph 72, where the court is identifying the key point of principle, beginning about halfway down paragraph 72. If a foreign state is committing torts within Canadian-controlled boundaries, Canada has the competence, derived from its independence, to bring the state within Canada's adjudicative jurisdiction. There would thus be sufficient connection with the forum state to justify bringing the foreign state's actions under Canadian scrutiny. So again, illustrating that certainly from the perspective of the Canadian Supreme Court, there's no problem at all, as a matter of principle, with subjecting a foreign state to that kind of scrutiny if it is committing torts within Canada's boundaries, which again obviously begs the question I need to get to under Core Submission 3. but illustrates that there's no problem in terms of interpretation, no problem in terms of comity, no problem in terms of customary international law, at least as viewed by one of the leading apex courts in the common law world. And it's all flowing from that core principle of international law, territorial sovereignty. Now, it's true, again, this was a point noted yesterday, that the wording of the Canadian statute is different and wider on its face than Section 5. But the outcome in Kazemi is not in any way inconsistent with our case as a matter of principle. The outcome was that an act causative of personal injury had to occur in Canada. That's it, and leads to the ultimate question on this appeal. Did such a causative act occur in the United Kingdom? So that's the comparative case law. The academic commentary doesn't get Bahrain any further. 3 texts were cited yesterday in this regard. We had Lady Fox, first of all, who we actually rely upon at paragraph 42D of our case, where she expresses the view that Section 5 is wide enough to remove immunity, even in a Lockerbie-type case, where on that scenario, of course, a bomb is put on a plane in Malta and explodes over Scotland. That would be sufficient in Lady Fox's view to fall within Section 5. The second...
In coming to that conclusion, she relied on the distiller's case, which
she did
might, at first glance, seem a little remote from what we can
My Lord, yes. I see that. And certainly Mr. Justice Stewart in Heiser didn't, and the Court of Appeal in this case, were reluctant to place too much weight on private international law cases in interpreting Section 5. But there it is, in terms of commentary. It's a conclusion, at least, on part of Lady Fox, which favours us rather than Bahrain. The second piece of academic commentary was Dicey and Morris, which the court saw for reference, it's page 3067. But that just doesn't address the point. All it does is indicate that assassination-type cases would be within Section 5, but it doesn't preclude other cases from being within Section 5. Then we had Dickinson, referred to at 3078, but that also doesn't offer an interpretation consistent with any of the interpretations offered by Bahrain. And so far as Dickinson is concerned, as the court will have seen, there's a very recent new work published by Professor Dickinson.
Just before you go to that, so I'm looking at page 3078.
3078, my lord, yes.
Yeah. Surely that is favouring your opponent's case. On balance, the former view is to be preferred.
Is your lordship in little a?
Yeah.
The act or omission referred to in Section 5 could be construed as being either, 1, the wrongful act of the state on which the claimant's action is based, or 2, the immediate cause of the injury in respect of which the claimant sues. We say, my lord, that we can satisfy both of those formulations in this case.
But they say on balance the former view is preferred. Anyway.
Yes, and I can satisfy the former view, I say, because I can base, if I'm right on them being acts, I can base my cause of action on the video surveillance, the audio surveillance, the opening of the safe in the UK, the removal of data and property from the safe in the UK, and so on. Those happen to be, when they're revealed, also the immediate cause of the injury, because they're the things that give rise to the psychiatric harm when they become known. So we don't have a problem with that.
I find it quite hard to see how the first view couldn't be preferred, given that the statute requires an act. But no.
There we are, my lord, yes.
But that's a point you've already made, I think.
Yes, my lord. But then we have, hot off the press, November 2025, put forward by my Lord Jones, I think, the latest from Professor Dickinson, which the court will have at, I think, tab 5 of the supplementary bundle, very helpfully prepared by my learned friends instructing solicitors, where a paragraph, well, beginning on
Can you
page...
give a page number?
Sorry, yes, it does have page numbers. I should have given those straight away. Page 90 is where it starts.
Thank you.
And it's page 93, where the tantalising heading caused by an act or omission in the United Kingdom appears. And we then have the author's analysis of what that means and the author's consideration of Shehabi in the Court of Appeal. And
I found that conclusion at point 12 on page 98 particularly helpful.
yeah, I noted that. By the way. I don't think any of us would disagree with that. One can only assume they weren't aware that permission to appeal had been granted at the time this section of the book was written, but there we are. What we
Perhaps
say...
they were aware of that.
Well, maybe they were.
Definitely.
I won't take time. Well, probably not my most important point.
Sorry, where were you taking us?
I would like
Mr. Proceed?
to emphasise, if I could, my lady, what is said at subparagraph 5 on page 95. And particularly the words beginning 6 lines from the bottom. If the representative of a state located outside the United Kingdom deploy an instrument that is activated or active in the United Kingdom, there will be an act in the United Kingdom for the purposes of the 1978 Act. So that is, although it cites to Shehabi in the Court of Appeal, that is actually the author's view as to how this works. And you'll see...
But is it on the basis of given the Court of Appeal's judgment, that's how it works? Or are you saying it's their independent view?
Well, it's not simply a question of this is what we think the Court of Appeal decided and we're agnostic as to whether it's right or wrong, see paragraph 12, because we see from what the authors do is develop what we would respectfully submit is in fact somewhat unnecessarily overcomplicated, complex composite act theory. But what they do in the course of that, at subparagraph 7, just opposite pretty much where we were, they advocate the right approach, and then they say, formulating the test as suggested here, requiring that all causative acts or omissions be located in the UK, would not affect the outcome, resulting in the application of Section 5 in a composite act case such as Shehabi or Al-Mazariya, in which the acts of espionage relied upon were held to have occurred in the United Kingdom, regardless of the fact that they had been initiated abroad. So the authors have no problem with on their theory, with the ultimate conclusion of the Court of Appeal, and we gratefully adopt that. We also say that, and it's perhaps to jump ahead to use someone else's words rather than mine, because they might be more persuasive to the core submission 3, we also do adopt with respect what's said at subparagraph 5 as a useful distillation of a common sense approach here. If a foreign state deploys...
Sorry, you're reading from 5.
From 5, yes. The beginning 6 lines from the bottom, the words accordingly.
Oh, yes, yes. Passage you referred to before.
That I've referred to. If a foreign state deploys an instrument of this sophistication, which is then activated or active in the United Kingdom, there's no difficulty, as a matter of common sense, in seeing that as an act in the United Kingdom.
That's your point 3.
Yes. So that's just to update the position in terms of academic materials. None of them go against the grain of what we submit the basic interpretation of Section 5 should be, or the Court of Appeal's paragraph 54. Ministerial notes I'll take very...
Have there been no case notes on either of the first instance or Court of Appeal decisions?
Not I've only found one, my lord, on a read of Westlaw from a no doubt excellent pupil at 20 Essex. He won't say more, but it's an accurate distillation of what was decided, rather than an analysis of whether it was right or wrong, or even to go as boldly as paragraph 12 of Dickinson did. So no, not that I'm aware of, my lord. We'll do another check. So that only leaves, in terms of other materials, informing this first question, what's the interpretation, before I get to international law, ministerial notes, and I'll be very brief on those. They're not admissible. There's no precedent cited anywhere by Bahrain to suggest that unpublished ministerial notes can be admissible as an exercise of statutory interpretation. And even as a fallback, well, they're jolly interesting and have persuasive authority in the way a textbook would. That's a pretty ambitious submission to make in circumstances where A, they're unpublished, B, they're undated, and C, we don't know who the author was. So that...
Can you help me? The Court of Appeal, and I may have misunderstood something here, but they did refer themselves, or sorry, Lord Justice Mail.
He did, my lord, you're absolutely right.
I couldn't find that in the bundle, but I may be...
Oh, I'm sorry, my lord.
I've missed
I've
it.
taken you to that. It's under the... it's page 158, where His Lordship is dealing with Article 11 of the Convention, at paragraph 57.
Yes, that's it.
Yeah, 58.
Is that in the bundle?
It is in the bundle, my lord. I'm sorry I don't have the reference to it to
anybody
hand,
got
but
the
it's in the same run of materials that Mr Hickman took you to yesterday,
Okay.
where he was referring to the notes for a different purpose, namely the reach of Article 24.
Could I just have that reference from somebody?
Yes, we'll
I
find it.
couldn't actually find it, but I may just have missed it.
And there are 2 points that the Court of Appeal make in respect of this. You see them at 58 and 59. Firstly, 58, to the extent one would have regard to this at all, it actually hinders Bahrain rather than assisting it, because it illustrates a deliberate departure being taken from the terms of Article 11. But in any event, and as the Court of Appeal puts it more fundamentally, they're not admissible as an aid to interpretation. And we say they're right on both points. So, my lord...
Well, even if it were admissible, it's hard to see why they'd be relevant.
Yes. Core submission 2, then. We say we've got to first base by establishing what on its face in the statutory context is a clear and unambiguous meaning. See paragraph 54 of the Court of Appeal. I'm very grateful. It's page 2308, my lord.
Thank you very much.
Second core submission is that clear and unambiguous meaning is not displaced by the terms of the European Convention on State Immunity or by any other sources of international law. And these are the submissions that we set out in our case at paragraph 4 and then at greater length 47 through to 66 of our written case. And again, I'll just headline them first and then seek to develop them, if I may. There are 5 basic points, we say, which lead to that conclusion that core submission 2 is right. Firstly, while the State Immunity Act was undoubtedly aimed at giving broad effect to the European Convention on State Immunity, it quite obviously did not simply replicate its terms. It represented a complete code. It dealt with immunity more broadly than the Convention did.
Sorry, could you a little more slowly, please?
Yes, my lord. It did not simply replicate its terms. It represented a complete code. It dealt with immunity more broadly than the Convention did. And
Do you mean immunity or with the exceptions, or both?
Generally, or...
Generally.
Generally,
Okay.
my lady, yes. and it diverged from the approach taken in corresponding provisions in the Convention in a series of significant respects, of which Section 5 was just one example. And so, perhaps to do justice to what we say the Court of Appeal was really getting at, it cannot be said that the or even a purpose of the State Immunity Act was to replicate the exceptions in Articles 1 to 13 of the Convention.
I don't think that's being suggested.
No, my lord. Well, but
The question is whether it was intended to be consistent with the Convention and whether on your interpretation it is.
well, my lord, I agree that is the answer to the question. To the extent that it's said that Section 5 should be read as including a presence requirement, that is, we say, in substance, a submission that rests upon a proposition that there was an intent to replicate Article 11 of the Convention.
I think it rests on a submission not that it was intended to replicate, but it wasn't intended to go further in departing from a starting point of immunity for sovereign acts.
I take that point, my lord, and I'll come to it in the context of Article 24 then. But that's our first point. The starting point is one of broad effect, and we have no difficulty with the idea, it's obvious, that the Act was intended to allow the United Kingdom to ratify. The key point, we say then, is, at this stage of the analysis, subject to the point I'll make in a moment about how you even get to the harmonious interpretation principle. The key point at this stage of the analysis is the second of my 5 points. The Court of Appeal's interpretation of Section 5 would not place the United Kingdom in breach of the Convention, in the perhaps unlikely event that another EWCA state were to engage in conduct of the kind alleged in this case.
Because of your interpretation of Article 24?
Exactly.
Right.
And the fact that the UK has made a declaration under Article 24 to give life to that interpretation. That's the second point.
But your argument depends on the declaration, doesn't it?
On the no breach analysis, it
Yes.
does, my lord. My
Otherwise,
argument,
there would be a breach on your case if there hadn't been a declaration.
yes, my lord. But my argument in the appeal as a whole does not depend upon that, because of my third point, which is that even if that were the consequence of the interpretation of the Court of Appeals, the interpretation of the Act arrived at by the Court of Appeal, if they were correct that that was the plain and unambiguous meaning of Section 5, then that's it. The duty of the court...
Well, at that point, you have to engage with not just paragraph 54, dealing with a number of acts, but paragraph 34 of their judgment,
Yes, my lord. But
which is the act, what counts as an act.
what counts as an act. But on interpretation,
I mean, if it was so clear what counts as an act that we should be regarded as having wished to, the UK Parliament should be regarded having to wish to enact that interpretation,
my lord, again,
even if it was a breach of international obligations, then we should recognise that.
My lord, I'm still seeking, if I can, to focus solely on the interpretive exercise here.
Well, it's all part of the interpretive exercise.
Well, our submission, my lord, is that the point my lord has been putting to me is part of the application exercise, not the interpretation exercise.
Well, this is completely artificial. with respect.
There's a
Tempted
question
to ask my
about...
lord
I mean, I'm just, you know, speaking for myself, I'm just waiting for you to get to the point that is really bothering me.
All right.
And all this is build-up, and that is the main point.
Well,
so I hope you're going to leave enough time to get to that.
So do I, my lord.
Well, I hope you- I hope
some of
you
us might
won't
be interested in other points.
Yes, I am
So-
interested in the points you're making, Mr.
I'm going
Otti,
to
so-
try and address...
You must take these points in your own order,
Yes.
Mr. Otti, and you allocate time as you consider appropriate.
Yes, I well understand the importance of the point my lord's put to me, and I will attempt to do it justice. Article 24 is also a very important point in this analysis, because if we're right on it, it disposes of the breach concern. And so, if your Lordship and my Lady will forgive me, I will deal with that.
So your third
Third point, my Lord, is that
position.
if we're right on clear and unambiguous, subject to the exchange my Lord and I have just had, then it doesn't matter if there's a breach. And that is clear on all of the authorities, whether it's Jones in this context, whether it's Salomon and the various other cases that Lord Diplock cited himself in after Salomon. You don't get to the principle of harmonious interpretation unless you've got ambiguity. So then the fourth point is moving on from the convention, the Court of Appeal's interpretation would not give rise to any breach of customary international law either. And the fifth point...
Sorry, the Court of Appeal interpretation not give rise to any breach of customary international.
And that's as a result of the submission I made yesterday. There is no requirement, and indeed repeated this morning, there is no requirement to grant immunity in proceedings in respect of personal injury caused by an act in the UK where the act is a sovereign act, save in that very specific armed forces context. And I'll come to that.
And that comes back to the last sentence of Article 24.
Come back to the last sentence. Well, no, actually, this fourth submission is based upon 64 to 65 of jurisdictional immunities. And
Okay.
So. Because this is dealing with customary international law breach as opposed to convention breach.
And that's 64 to 65 of jurisdictional immunity.
Yes, madam. And then the fifth point is that it is wrong to say that adjudication of this claim would either involve adjudication on the legality of decisions taken by foreign officials in Bahrain or be unprecedented. It would, on our case, involve adjudication on the lawfulness of conduct occurring in the United Kingdom by reference to English law, just as the courts were able to adjudicate on very similar matters in the Al Maktoum litigation. So, I will speed up as far as I can. The first of those points, purpose of the act.
We've got to take a note, Mr. Rogers.
Yes,
so I don't think you should feel...
Quite a lot of time, anyway.
Yes, you've got until, I think, 20 past 3 this afternoon.
I'm very grateful, my lord. So the first of the points is the general one about the purpose of the State Immunity Act and its divergence in a series of respects, including Section 5, but not limited to it, from the Convention. And we've addressed this in our written case at paragraphs 47 to 48, and we've cited FG Hemisphere, as the Court of Appeal did. We've also referenced Lord Sumption in Benker Bush, describing the State Immunity Act as dealing with immunity more broadly than the Convention and as a complete code. And Finally, and not in the written cases, we have Argentum in the Supreme Court and the judgment of my Lord Lloyd Jones and Lord Hamlin. And that's again in the supplementary bundle, and it's perhaps helpful just to reference it. It's the first document in the supplementary bundle beginning at page 3. And the material paragraphs for present purposes are paragraph 25, page 19, describing the Act as a new statutory scheme providing detailed and comprehensive rules, the complete code point. Paragraph 26, describing the background to the Act as lying in the point I've already acknowledged, a desire to become a party to the European Convention on State Immunity as well as the Brussels Convention. Paragraph 27, the long title to the Act. paragraph 28, where the exceptions to immunity are summarised in short form. And then at 29, it said, the various jurisdictional connecting factors provided for in the European Convention are generally implemented in all of the exceptions to immunity. And we obviously emphasise the word generally. That's accurate as a result of the word generally, but there is significant divergence, and this is something that it's obvious in relation to Section 5 and Article 11, as I've already been making submissions, and Professor Webb will address the court in due course on other illustrations of divergence, not least because at paragraph 30, your lordships say, as Fox and Webb point out, the State Immunity Act makes considerable departures from any application of a distinction between acta jure imperi and acta jure gestionis in removing immunity for all contracts performable wholly or in part in the United Kingdom and for specified transactions of sale of goods, provision of services or loans, and for claims relating to personal injuries, in Section 5 point. Consistent with all of these statements, the general purpose of the State Immunity Act was to allow ratification, but not simply to replicate in precise terms all the exceptions to immunity as set out in the Convention. Different, for example, to other legislative techniques, whether it's the Diplomatic Privileges Act or otherwise, where you simply incorporate root and branch wording from an international treaty. The important second submission then I get to is there would be no breach of the Convention as a result of the Court of Appeal's interpretation of the Convention. And that is a submission we advance at paragraphs 50 to 57 of our written case at pages 119 to 121 of the core bundle. And the first point is that the exceptions, on the basic structure of the Convention, Articles 1 to 13 are not determinative of the jurisdiction of a forum state. And that is because of Article 24 of the Convention, expressly permitting a contract state to declare that in cases not falling within Articles 1 to 13, its courts shall be entitled to entertain proceedings. And the reference is 2537 in the bundle.
But that declaration is without prejudice to immunity.
I have to deal with that, my lady, yes.
That's the problem.
Entirely accept that.
Emma, there's for a moment, if you would.
That's where the debate...
That's where the argument comes.
That's where the argument comes, my lord. The first stage in the argument is that Articles 1 to 13 don't occupy the field. Second factual stage in the argument is the UK has made a declaration, and the court saw it yesterday. It's at 2583. So the key question is how do we interpret the last words of Article 24 as mirrored in the UK's declaration? And this is an area where we say that there is significant assistance to be gained from the explanatory notes to the European Convention. And we've set out the key passages for the court to reference at paragraph 52 of our case, page 120 of the core bundle, but the passages themselves begin at paragraph 96 on page 2570.
Sorry.
2570, my lord, is the explanatory notes and the section dealing specifically with Article 24. And the first significant point comes from the first paragraph within 96. Certain states which at present apply rules of qualified state immunity considered that Article 15, which provides that immunity must be accorded to states in all cases other than those falling within Articles 1 to 13, was too rigid, either because some acts iure gestionis fell outside the cases covered by these articles, or because the connecting links prescribed in these articles do not correspond with the rules of jurisdictional competence applied in those states. Article 24 permits states to derogate from the provisions of Article 15. So that, we say, is significant because Article 24 is coming against the background of an express contemplation that signatory states might prefer a different approach to the particular jurisdictional connecting links set out in Articles 1 to 13. And that is, of course, precisely, subject to dealing with the sovereign immunity point, which I'll come to in a moment, precisely the divergence which we say occurs in this case between Section 5 and Article 11, because Article 11 has the presence requirement and the facts requirement, and Section 5 doesn't. Secondly, also at 96, consistent with that desire to avoid rigidity, in the next paragraph, the explanatory note goes on to summarize the effect of Article 24 as being, in the last 4 words of that second paragraph, the regime applied by the courts of a state which has made the declaration will not be affected by the convention and can even continue to develop along its own lines. So once again, a declaration is made and divergence with particular provisions of Articles 1 to 13 is expressly contemplated.
You have to look at the next
And
paragraph.
then we have to look at the next paragraph, my lady, and it notes that in line with Article 24 itself, that a declaration will not affect the immunity from jurisdiction enjoyed by foreign states in respect of acts done in the exercise of sovereign authority. Now we say, as we've said in our written case, that qualification merely begs the question as to the scope of immunity in respect of such acts performed in the forum state and having proper regard to the principle of territorial sovereignty.
So you say it refers to such immunity as may be enjoyed in respect of sovereign activities?
Yes. And that is question begging. It's not doing what Mr. Hickman wants it to do, which is expressly preventing any further immunity than contemplated in Articles 1 to 13, touching upon sovereign acts. And the only absolute bar we actually get from Article 24 is actually illustrated in or at least from the notes, I should say, in Article 24, on Article 24, is what we get from the next paragraph, paragraph 97, where there's a reference to proceedings within the grey zone, namely in matters not covered by Articles 1 to 13. And that's provided, it's said, by Article 24.2, as precluding jurisdiction founded on so-called exorbitant jurisdictional grounds, which are themselves set out in an annex to the Convention, which the Court has at 2543. You don't need to turn them up, but the exorbitant grounds are essentially presence of a defendant's property in the forum state, plaintiff's nationality or residence, defendant carrying on business in the forum state, or a unilateral specification of forum by a plaintiff. So nothing to do with our case.
Is this because the Convention is also concerned with the enforcement of judgments given against contracting states?
Yes, my lord.
Yeah. So you have to have an appropriate jurisdictional link.
Yes, my lord.
We're not concerned with that.
We're not concerned with that, but the significance of 97, for our purposes, we say, is that it's saying what is off limits by way of development in relation to following an Article 24 declaration. And then just to complete it, we get, again, a comment in similar vein, paragraph 99, a state that well, of course accept is general, but a state that makes a declaration under Article 24 opts for a system according to which its courts may exercise jurisdiction even as against contracting states in cases other than those provided in Articles 1 to 13. And that's also consistent with the breadth of the wording we contend for. Now, as we've already identified in the court's observations to me, Bahrain, of course, contends at paragraphs 89 to 92 of its case that the Article 24 declaration has no effect in this case because the terms of the last sentence of Article 24 mean that it can't have any impact at all on conduct which is properly characterised as jure imperii. That's not what Article 24 actually says, or what the United Kingdom Declaration achieves. They state simply that the declaration is without prejudice to the immunity from jurisdiction which foreign states enjoy in respect of acta jure imperii. But as I say, that is inherently non-determinative and question-begging. And that characterization of it as non-determinative and question-begging is borne out by a series of factors, we say, at least one of which was identified by, or at least we understood it to be identified by my Lord Jones yesterday when it came up in Mr Hickman's submissions. And that is that the European Convention on State Immunity does not itself seek to preserve immunity across all fields of acta jure imperii. That's the point we make at our written case at paragraph 56. It's also borne out, we say, by the fact that the domestic legislation doesn't seek to achieve that outcome either. And it's borne out by the fact that the International Court of Justice, for its part, has only drawn a clear line around conduct of the armed forces engaged in armed conflict as being inevitably immune. And it's expressly left open the question whether, as a matter of customary international law, there is a tort exception applicable. And that's the point we make at paragraph 60 of our case by reference to jurisdictional immunities case at 64 to 65 and 77 to 78. We say that, with respect, the Bahrain's case on Article 24 is circular. It doesn't answer the question what immunity applies to acta jure imperii in the forum state's jurisdiction. And importantly, as the explanatory notes show, the genesis of Article 24 lay in part, at least, in differing approaches as to the requirements of territorial nexus. And the effect of Article 24 is, we say, clearly and accurately summarised in the explanatory notes. Once a declaration is made, it allows a state's regime to develop along its own lines, provided only that exe states are not treated in a less favourable manner than non-exe states. So, in other words, what the Convention is making clear, read as a whole, is that at a minimum there will be incursions into sovereign immunity as reflected in Articles 1 to 13. But if further incursions are applied to non-exe states, and if an Article 24 declaration has been made, then those further incursions may be mirrored in relation to exe states too.
Sorry, you're going to have to repeat that.
Yes, my lord. So what we say the Convention is making clear is that at a minimum there will be incursions into sovereign immunity as set out and reflected in Articles 1 to 13. And the work that Article 24 then does is to show that if further incursions are applied to non-EXI states and an Article 24 declaration has been made, then those further incursions may be mirrored, entirely consistent with the obligations flowing under the Convention.
Sorry, if they're extended to non-EXI states and a declaration is made.
Then those further incursions applied to non-EXI states can be mirrored in relation to EXI states. So, I think I've made the point, but the reference in Article 24 to jus in peri indicates no more than that, to the extent that customary international law requires immunity for such acts, that will be preserved, but no more and no less. And as I say, it's question begging.
Apart from the explanatory notes, is there any further material that sheds light on this or further supports
Not that I'm
that or
not that I'm
contradicts it,
aware
or
of, my lord.
cases or commentary?
No.
Nobody's addressed it.
It would make no sense also, as a matter of coherent interpretation of the Convention as a whole, for Article 24 to be read as requiring immunity for all sovereign acts, because we know already that Article 11 at least already does not adopt that approach. So that's what we say about Article 24, my lords, my lady. And that was my second of 5 points under this submission. The third one, which I think I probably need do no more than simply recall, was that the terms of the Convention as an unincorporated treaty don't displace the clear and unambiguous words if, and it's a big if, I appreciate, but if I'm right on that clarity and lack of ambiguity, as the Court of Appeal put it.
Why do you describe it as an unincorporated treaty?
Because, my lord, it's not, for example, a situation where the words of the Convention have been directly incorporated. It's distinct from the Diplomatic Privileges Act and the Vienna Convention on diplomatic relations in that.
That was done by annexing the text as a schedule to the statute.
Exactly, my lord.
But a treaty can be implemented in various ways, and it's not necessary to do that.
Yes, my lord.
Now, we take your point that there was not an exact replication here.
Well, I obviously entirely defer to my lord on the precision of the terminology, but the key point I'm making is that, and it's indeed how Bahrain puts its case, we're either in harmonious interpretation treaty territory or not.
So your point 3 is that...
My point 3 is you don't get to the harmonious interpretation principle because the words are so clear and unambiguous.
Thank you.
And that's even in a context where, as I accept, the intent is to allow ratification.
So on that view, it would be an inadvertent consequence of the language used.
I'm sorry, my lord.
If that submission were, on that basis, if it produced an inconsistent interpretation, it would be an inadvertent consequence of the drafting, because we're to presume that the intention was not to breach the Exit Convention.
Yes, my lord.
But you'd only get there
Exactly.
if you were wrong about Article 24.
Of course, your primary argument is that it's consistent.
No
but,
problem.
You're wanting to say that even if it's inconsistent.
Exactly. And I rely on Salomon and Eshersheim and everything else, that to get to harmonious interpretation, you've got to show ambiguity or lack of clarity. Simple as that. So that's the Convention, that's Article 24. And then the fourth point on this core submission 2 is the Court of Appeal's interpretation would not place the United Kingdom in breach of any other international law obligations. And to some extent, similar points to the ones I've been highlighting in relation to Article 24 apply. As we seek to explain in our case at paragraphs 59 to 64, there is nothing inconsistent with customary international law in the approach taken by the Court of Appeal. The first point we make at paragraph 60 and 64, of our case is that the Court of Appeal had close regard to what this court, what the ICJ, and it described as the twin principles underpinning the law of sovereign immunity. In particular, the principle of territorial sovereignty. Secondly, in circumstances where it is now conceded that Section 5 creates an exception to acta iure imperii, just as it does for acta iure gestionis, there's no basis, we say, in principle for contending that incursion in respect of the former has to be particularly restricted. The past has already been sold, so far as the State Immunity Act is concerned.
Well, that depends on your starting point. If your starting point is that the basic principle of international law is that sovereign acts are immune, save to the extent where there's been a customary practice established to the contrary, which is the appellant's position, then the debate is about whether the EWCA Convention has done enough to depart from customary international law. It
Yes.
seemed to be the argument in the Italian prisoners of war case.
So I take that point, my lord, and it would give rise to the question whether Section 5 is itself a breach of customary international
Exactly.
law in
So
even
that-
contemplating
this-
any tort exception.
So this seems to me at the moment a very important question
My lord,
in terms
yes.
of how one approaches the case.
For these purposes, again, I hope not too pedestrian a fashion, what I'm doing is illustrating that the Act, at least, does not draw any material distinction between imperii and gestionis.
Yeah.
And that's also consistent with the view of the Act expressed by the academic commentators. And that's a point we've made in our case at paragraph 62, I should say.
And the same is true of EWCA and the UN
Yes,
Convention.
yes, Article 12, Article 11 clearly contemplate, we say, and Article 12, we've got the commentary that Mr. Hickman showed you, clearly contemplated sovereign acts being caught within that exception to immunity. And so that does indeed it takes one to the key, one of the key questions on this appeal that was raised by the registry on Monday, which gives rise to the starting point question that my lord's just referred to. Does customary international law require the grant of immunity in respect of personal injury caused by a sovereign act in the forum state? And we say it doesn't, save in that very specific context of a foreign state's armed forces engaged in the conduct of armed conflict. And we rely upon a series of sources in that regard. Firstly, we rely upon the International Court of Justice in jurisdictional immunities at 2634, paragraph 64 to 65, and then the court's ultimate conclusions at 77 to 78, 2641 to 2642, where, as the court has seen, the Court of Justice found only that it is that category of armed forces and other conduct that I've just referred to in the forum state under customary international law, expressly leaving open the possibility that there is now a territorial tort exception to acta iure imperii, as the court put it at paragraph 65. Now, as my Lord's just identified, Bahrain, of course, seeks to narrow the observations of the Court of Justice by referring to the fact that Italy was relying only on, or primarily on, Article 11 of the European Convention on State Immunity and Article 12 of the UN Convention on State Immunity, and so it was. But that is unsurprising, and we say does not materially qualify the landing point of the Court of Justice. Italy, of course, was expressly relying upon those because it was complaining of conduct occurring while there was physical presence on the part of German forces in Italy. It didn't need to go any further than that. We say the wider point, which the Court of Justice was leaving open at paragraph 65, was whether there was now a tort exception to sovereign immunity applicable to acta iure imperii in general.
But what's quite clear is you can't rely on the UN Convention and Article 11, as Italy did, to support your argument that the territorial exception goes as wide as you wish it to be.
I can't put in those terms, my Lord, no. I do rely upon them as illustrative of the fact that there is a tort exception.
But one that's qualified by a physical presence requirement.
Well, that's right, my Lord, and that's why
limited by that requirement.
That's why we say you end up getting into a chain of analysis which is not dissimilar to that identified in Benkabush. The starting point, illustrated by the two conventions and illustrated by a range of other matters I'll go to, the starting point is that there is no absolute immunity for sovereign acts in a forum state where those sovereign acts involve tort causing personal injury. That's the starting point. Just as the starting point that had to be considered in Benkabush was restrictive immunity applicable to employment contracts. And if that's the correct chain of analysis, then after you've got that starting point, you ask whether there is crystallized in international law a requirement, nevertheless, to afford immunity.
But how have you got to the starting point, except by relying on Article 11 and the UN Convention to displace the immunity for sovereign acts when it's acts done in somebody else's territory?
You've got to the starting point by the headline fact that those conventions establish that there is no absolute immunity for sovereign acts within a forum state. They adopt a particular definition as to where the boundaries will lie and where immunity may still be required. But the starting point is correctly identified as there isn't any immunity as far-reaching as that as a matter of customary international law.
But then you seem to be relying on those materials to prove more than they can establish.
Well,
that you want to say they break down the inhibition against immunity for acts in another state generally, and now it's open to further expansion. But
now it's open to crystallization.
One might say that they only break it down to the extent that they say they
break it down. Well, that's my submission, my Lord, that they allow that gateway to be forced open. We say it's a position which is also reflected in state practice in the form of legislation, albeit I acknowledge that the legislation is, in some instances, differently worded to the State Immunity Act, in some instances worded in precisely the same way as the State Immunity Act, but without court decisions explaining what they mean. But
Mr. Rossi, I think your position is, as I understand it, is that you can show that there's no absolute rule of immunity in respect of sovereign acts for
Yes.
torts within the jurisdiction. You said thereafter the burden passes
Exactly.
to the appellants in order to show what are the problem limits.
Exactly so, my lord. And that's why I say it's exactly the same. It's analogous to the chain of reasoning and analysis that was followed in Benkerbouche, where Lord Sumption said the Secretary of State's got the wrong starting point here in saying it's absolute immunity for everything, and it's down to the employees to demonstrate a crystallised exception to immunity. So too here, we say Bahrain has the wrong starting point. There's no absolute immunity in respect of sovereign acts in a forum state causing personal injury. It's not down to us to crystallise anything beyond that, and instead it's down to Bahrain to say, no, the only exceptions, the boundaries of the tort exception have crystallised in this way, and they don't get you home, and they've not sought to take on that burden.
Well, arising out of that, why should presence within the jurisdiction be the measure of the scope of the exception?
The presence within the jurisdiction, my lord, we say it's one way of expressing sufficient territorial nexus to trigger application of the principle of territorial sovereignty, but it's not the only way. See the observations made in the explanatory note.
Yes.
And so the key question, which we say gets me into the territory of this being available as a route, is that a territorial connection between wrongdoing and forum state displaces absolute immunity for sovereign acts. And then it's over to Bahrain to do what it can. Now, so far as other legislation is concerned, we've got the references in the some references in the jurisdictional immunities judgment itself, at paragraphs 64 and 70. And
Sorry, you're going where now?
64 and 70 of the jurisdictional immunities judgment.
Yes.
And that's 2634 and 2637. And we've included some of that legislation, but not all of it in the bundles, which the court saw yesterday. If it's of assistance, and I'm afraid it's only a machine translation, but in certain respects, we've prepared an updated table setting out what's in the jurisdictional immunities case, what's in the bundles, and what's happened since jurisdictional immunities, which I could hand up.
That would be very helpful. Thank you very much.
It would help me if you've got time, but you may then also to explain your analogy with Benkerbouche that you relied on.
Yes, my lord.
I thought the question there was about whether employment was a sovereign act or whether it was a private act.
That's the ultimate question, my lord, as
Yeah.
to whether sovereign immunity applied on the particular facts of the cases before the Supreme Court. But the first question was, what is the right starting point? And so to lead into who bears the burden of demonstrating what in terms of customary international law. And Lord Sumption explained that the right starting point was one of restrictive immunity, and therefore it was for the Secretary of State to justify the particular exceptions to jurisdiction, even in a restrictive immunity context.
But isn't that because restrictive immunity it doesn't, you're dealing with the question of acts that are not part of the core of exercises of sovereign authority?
Yes, you are, and that's
And
why.
when you're in that territory, then the burden must be on the person to show that the immunity extends more widely.
Yes, my lord. So this argument hinges on me being able to satisfy the court that we are in analogous territory by demonstrating that, as a matter of customary international law, there is no requirement to afford immunity for tortious acts in a forum state. And we say we can do that by the conventions, by what the jurisdictional immunities judgment said, and by illustration from legislation and commentary.
Thank you.
So the legislation, rather to my surprise, actually, when Professor Webb very helpfully produced this to me, China takes a more enthusiastic approach to forum state jurisdiction than one might have anticipated.
I thought China was one of the states that was identified in the ICJ decision as
Yes.
having reservations about it.
I'm not sure China... Sorry. This is 2024 legislation, so it's come after
Right.
jurisdictional immunities judgment. But it brings the position up to date. And so it's a set of legislation illustrating, again, albeit in varying terms, albeit in terms which are, even if similar to the State Immunity Act, not subject to judicial consideration in other states, that there is a territorial, there is no requirement to provide immunity for territorial tort. And that is also a conclusion which flows, we say, from the two conventions. And it's also a conclusion which flows from those domestic court judgments which have looked at the question of their own legislation and the tort exception. The Canadian Supreme Court expressly rejected the suggestion that Section 6 of the Canadian legislation provided no exception in respect of sovereign acts. It did that in the Schreiber case, which the ICJ itself refers to at paragraph 64. For the court's reference, it's at 2847 to 2849, paragraphs 32 to 36. That approach, unsurprisingly, was entirely consistent with the core point of principle that I showed the court earlier from Kazemi, from the same court, namely that what mattered in terms of the legitimacy of asserting jurisdiction by the forum state was that the foreign state had committed torts within the territorial boundaries. And it's consistent also, albeit I don't like it for other reasons, it's consistent also with the case law of the United States. Because as we've seen, Letellier is a paradigm example of a sovereign act still being susceptible to adjudication in a forum state where it has caused a tort. Sorry, where it has involved a tort causing a personal injury.
But what you can't point to is any case in which there hasn't been an act by somebody present within the jurisdiction.
No, my lord.
And that's what you want to say here is not immune.
I want to say there's no requirement to afford immunity in such a context.
Yeah.
We've got illustrations of the same point, that there's no magic about sovereign, non-sovereign in the tort context from judgments in this jurisdiction too. I've shown, none of them meeting my Lord's point, but making that general point. I've shown the court already Argentum at paragraph 30, which makes that point in relation both to section 5 and to section 3 of the Act. Alazzani in the Court of Appeal, Lord Justice Stuart Smith and Lord Justice Ward treating the State Immunity Act as a complete code, not subject to overriding considerations, and proceeding on the clear assumption that if the torture alleged in that case had occurred in the UK, it would fall within section 5 of the Act, notwithstanding its inherently and obvious definitional sovereign nature. We've got my lady's judgment in Zu Wittgenstein, the Juan Carlos case in the Court of Appeal, where it's accepted that pre-abdication covert surveillance is the classic business of a state intelligence service. so giving rise to prima facie immunity, but that then requiring, as my lady put it, consideration as to whether the Section 5 exception applied, even to that sovereign conduct. And as my lady will recall, it didn't apply in that case because it hadn't been properly pleaded as a personal injury case. So that's case law, all consistent with the general grain of the submission I make. And then fifthly, we have academic writings on the subject, again squarely against there being any clear sovereign, non-sovereign divide when it comes to determining the availability of immunity in respect of torts committed in the forum state. We've got in that regard Dicey and Morris, which I've referred to already, where it deals with the assassination context, 9050 at page 3068.
Sorry, 3068.
3068, my lord. We've got Fox and Webb correctly characterising both the Convention and the State Immunity Act as giving no relevance to the sovereign, non-sovereign distinction. That's 3124 and 3198. And then we've got, from a writer sometimes, probably risk doing an injustice to him, but sometimes cited, at least has been cited against me before, as illustrating a relatively conservative view of immunity. Professor Yang, we've got him saying, and this is 3346 and 3367, describing the position that as being that provided a territorial connection can be established, jurisdiction is based on the fact that some act or omission of a foreign state has resulted in injury or damage, but not on the nature of the act or omission, is a widely accepted rule. So focusing again, as we do, on this critical point, one of the twin principles of international law, territorial sovereignty, as providing the gateway for our submissions. And then we've got the International Law Commission articles at 2697, which is the passage that, rather in my excitement of being on my feet, I butchered the presentation of yesterday afternoon, but it's 2697, with the ILC giving its observations on Article 12 of the UN Convention. And we have paragraph 8 on 2697. The basis for the assumption and exercise of jurisdiction in cases covered by this exception is territoriality. The locus delicti commissi offers a substantial territorial connection regardless of the motivation of the act or omission, whether intentional or even malicious, whether accidental, negligent, inadvertent, whether jure imperi or jure gestionis. So irrelevant to Article 12. And then the passage I was trying to get to yesterday, for what it's worth, at subparagraph 7, just above, where the authors of the commentary are attributing significance to the insertion of a presence requirement as providing the answer to an assertion of jurisdiction over transboundary torts. Compare and contrast here, we say the absence of a presence requirement in Section 5.
But so what do you draw from that?
We draw from that it's an illustration that if you have a provision without an express presence requirement on a natural approach, there's no problem with transboundary torts, even if that's how this were to be characterised. And
your argument is that once you've got no longer a need always to have a sovereign act abroad, then all bets are off. And now, as long as there's a sufficient territorial connection, you can apply jurisdiction even to sovereign acts. even though it's going beyond what the UN in the previous paragraph said would be acceptable.
Unless Bahrain can show that those exceptions reflected in the UN Convention or the European Convention themselves crystallise customary international law. Yes, Mo? That leaves only the fifth point on this core submission 2, which again I'll try and take quite briefly because it's less important than the matters we've just been making submissions on. But it's to emphasise that adjudication of this claim would not involve adjudication on the legality of decisions by foreign officials in Bahrain or be unprecedented. Now, as to
Are
the
we
fir-
moving into the area of active state?
Yes, my lord, and it's why it came up in the Court of Appeal, because Bahrain's submission at that point was that the application of the Foreign Act of State doctrine reinforced its submissions on state immunity. That's not a submission that's been persisted with. It's still of assistance, we say, to consider the Al Maktoum litigation for two reasons. One, the Court of Appeal certainly was happy to describe what the allegations against the father amounted to as UK hacking. I'll show the court the passages in that regard. And secondly, because both Mr. Justice Chamberlain and the President of the Family Division at first instance and the Court of Appeal found that there would be no difficulty in terms of comity in an English court adjudicating upon allegations of this nature, notwithstanding the fact that they went on the mother's case right to the top. So that's Al Maktoum, which I'll come to. But the first point to emphasise, my lord, is that what on an analysis of the legal claim presented here in these proceedings would be required in terms of adjudication by a court, were that to occur. And the Court of Appeal, paragraph 69, page 162, said this: the English proceedings will be concerned with the act of infecting the claimant's computers within the UK. The fact that the agents who caused this to happen were located in Bahrain at the time, if that proves to be the case, is immaterial. It is equally immaterial whether whatever was done in Bahrain was lawful under the law of Bahrain. And then the Act of State principle doesn't protect a state which chooses by an act committed within the United Kingdom to infringe the territorial sovereignty of this country. And we would adapt and apply that to say customary international law doesn't protect a state which chooses, and so forth. Now, that was correct as a matter of legal analysis as to the domestic cause of action, because the claim here is under the 1997 Harassment Act. It will be governed by English law as the place where the injury complained of occurred, and that would be the case whether one applied the Rome II regulation or the Private International Law Act. It will require proof only, as we see from the Court of Appeal's helpful summary of the content of the tort of harassment at paragraph 16, it will require proof only of a course of conduct which a reasonable person ought to know would amount to harassment. And back to the point that I was making to my lord earlier, the multiple acts which we say occurred in the United Kingdom would readily cross that threshold, both in terms of course of conduct and in triggering what a reasonable person ought to know. So you don't need to rule upon anything to do with Bahraini law. And so far as
Sorry,
Al Maktoum...
I didn't
I'm sorry.
hear that. You don't need to rule on anything to do
with Bahraini law.
Bahrain law.
There will be no, as the Court of Appeal put it, no adjudication as to the legality of conduct under Bahraini law. So that then leaves Al Maktoum, and I accept entirely that it is distinct in the sense that it was a case about foreign act of state. As a matter of history, it's not, I don't think, reflected in the judgments, but as a matter of history, the father, when first confronted with these allegations, said in his position paper to the court, this raises serious issues of state immunity and foreign act of state. But in the event, he only pursued foreign act of state as an objection to jurisdiction. But we say it's of assistance because one of the core points made particularly clearly by the President of the Family Division and Mr. Justice Chamberlain was to say that there'd be no problem in terms of comity in an English court adjudicating upon allegations of this kind. And on the contrary, it would undercut United Kingdom sovereignty not to so adjudicate. Now that, of course, has to be read in the context of the fact that there were ongoing wardship proceedings and that the hacking in that case was alleged to be, amongst others, of Princess Hire's legal team. But the point remains, we say, of some force in terms of undercutting of United Kingdom sovereignty in this case too. And that's the point we make in our case at paragraph 66.
And the reference to the judgment of...
The reference to the judgment, my lord, is 487 of the bundle.
Thank you.
And I'll just show the court very briefly the first instance judgment and the Court of Appeal judgment. So we have 482, the judgment begins. We have the key passage relating to the third rule of foreign act of state and the reason it didn't apply, set out in paragraphs 67 through to 68 of the judgment at pages 500 to 501. And for the purposes of application to this case, I should show the court that the one of the issues in the case was whether the rule of act of state had any application to conduct, to acts done or having effects in the United Kingdom. We see that in the court's summary of the law at 64C at 499 to 500. We see at 66 the court assuming in the father's favour that this was sovereign conduct. And then at 67 through to 71 setting out the facts that said foreign act of state would not bar adjudication here. And in the first paragraph, we have a description of the acts alleged as being directed against and as having direct effects on persons in the United Kingdom and within the jurisdiction of this court. If proven, they would also constitute a serious interference with the process of this court, distinguishing a case which my Lord, Lord Lloyd-Jones may remember, Khan and the Secretary of State, which was actually a drone case relating to attacks or an alleged murder in Pakistan as a result of drones operated by United States operatives, as being described by the court as a rare, if not unique, example of the application of the third rule to acts taking place outside the territory of the state concerned. So an apparent treatment there, at least of the Khan drone context, of acts occurring in Pakistan, not the United States. And then the comity point is paragraph 71.
Where was the operator of the drone in Khan?
In this country?
Somewhere in the United States, but I don't...
Somewhere in the United Kingdom, surely. Wasn't that the point?
No, the point...
No, that's why I asked the
Oh, I
question.
see. Sorry, I thought...
No,
Well, then how could it have engaged us?
No,
It was GCHQ, was it, or something?
my lord, yes. The allegation essentially was that by providing intelligence to the American drone operator, GCHQ was complicit in
I see.
the unlawful conduct.
Thank you.
Paragraph 71 is the comity point. To adjudicate on the mother's allegations would not demonstrate any lack of respect for the principles of comity or the sovereign equality of states. On the contrary, a decision to abstain from adjudicating on these allegations would seem to us to undercut the United Kingdom's sovereignty and to be inconsistent with the duty of the court as an organ of the United Kingdom to secure the fullest possible extent the welfare of its wards. And so I of course acknowledge it's a different context, a wardship context, but the policy point we rely upon is there, that if, and it flows and is entirely with the grain of the Canadian Supreme Court in Kazemi and so forth, where is a foreign, and what the Court of Appeal said in this case at 55, where as a foreign state you engage in conduct which amounts to a tort and causes personal injury in a foreign state, there's going to be no problem of comity. On the contrary, you'd be undercutting the sovereignty of the foreign state to be allowed to participate in conduct of that nature without risking adjudicative jurisdiction.
Because this was a case about invasion of privacy, though, wasn't it?
It was a case about what, my lord?
Privacy rights.
Well, it was a case about unlawful hacking.
I know, but it wasn't founded on personal injury, was it?
No, my lord, no, it's not a state immunity case. And so it's not...
I mean, on any view, invasion of privacy by a foreign state is not... is protected by state immunity.
Yes, my lord, I'm sorry, I wasn't clear. I'm not relying upon it. My lord, Lord Lloyd Jones asked yesterday whether there were any references to where the acts took place when we were looking at Al Maktoum.
Right, I see.
And I refer to them for what they're worth. The reason I rely upon this authority is that it, we say, draws the sting from any submission that adjudication in this case would cut across comity.
Right.
The Court of Appeal, again, it's only for what it's worth, but the Court of Appeal on that first point dismissed the father's appeal and in its judgment described the illegal surveillance alleged as illegal surveillance in the UK. So for what it's worth, that's an indication, we say, of a common sense view of what is occurring. That's paragraph 31 of the Court of Appeal's judgment. But it only goes so far. I accept it's not a case where Section 5 was being debated and not a case where the point that my Lord and Lord Burrows have been putting to me arose for decision. So that does take me to the destination that Lord Burrows was encouraging me to get to earlier, which is call submission 3. And the question, we say, applying the Court of Appeal's interpretation to the respondents' allegations in the present case, the Court of Appeal was correct to conclude that these proceedings are indeed in respect of personal injury caused by an act or acts in the United Kingdom. And this was the appellant's ground 1 in the Court of Appeal. It's become their ground 4, I think, on this appeal, but in any event, it's in play, of course, and it's addressed by the Court of Appeal at paragraphs 26 to 46 of its judgment, pages 151 to 156 of the bundle, and in the respondent's case at 78 to 85, paragraphs 128 to 130.
Sorry, paragraphs?
I'm sorry, but 78 to 85, pages 128 to 130. Thank you, my lord.
Thank you.
And the Court of Appeal rejected the appellant's arguments on this issue on 3 primary bases. Firstly, as its summary of the respondent's pleaded case at paragraph 27, core bundle 151 showed, in its view, a host of relevant acts were alleged to have occurred in the United Kingdom. And that's, as I say, paragraph 27 of the Court of Appeal's judgment, where it sets out the particular passages in the particulars of claim which make the point about conduct in the United Kingdom, which you weren't shown yesterday, but there's no dispute about the content of the pleading. All of them, we say, on a natural, first impression at least, a non-artificial analysis, we say, I'll come back to that, speak of conduct in the UK and acts in the UK. Installation of spyware on the respondents' devices in the UK, running of spyware on those devices in the UK, gathering and extracting of information from the devices in the UK, sending and receiving data within the UK, recording and surveillance at the respondents' homes in the UK using microphones and cameras. So we are a million miles away, we respectfully submit, in terms of substance and common sense, from the attempted characterization by Bahrain of our case on conduct as just a load of technological processes. Or, to give the example that my Lord Burrows quite understandably put, and we wouldn't have a difficulty with, a mere technological routing of something through the UK to a device elsewhere by someone based elsewhere wouldn't, as a matter of common sense or non-artificial interpretation, trigger the application of Section 5. But we're not in anything like that territory.
Why wouldn't it, on your submission?
Because there's nothing of substance occurring in that respect. There's a conduit pipe.
So it's got to be an act, what, of substance?
The safe isn't located there, to adapt that metaphor. The property in the safe isn't being extracted from there. The camera isn't being turned on there. The microphone isn't being turned on there.
But it's causatively essential to go through the UK.
Yes, and I'm not relying upon a but-for test.
So the test becomes, it's got to be what? An act, but you say not merely an act. It's got to be something substance.
An act which is not remote, not peripheral, as a matter of common sense, is described as an act.
Well, I don't think we want to rely on common sense. Because, as Lady Hale has many times said, your common sense is not necessarily my common sense.
I take that point, my Lord, and I was conscious when reflecting on my Lord Legate's question yesterday that there was a real risk in trying to answer what artificial meant by answering with an equally elusive term. But one's got to start somewhere.
Yep.
And one's got to apply the words that Parliament has used. And there's nothing, well, as my Lord says, there's maybe different views as to common sense, but we say where you've got that set of facts, that factual matrix, any reasonable objective view leads to the conclusion that acts are occurring in the United Kingdom. Now,
so the essence of the argument is that acts are divorced from a human being being there at the time.
they don't need a human being to be there at the time.
Is there an act in Bahrain which causes an act in the United Kingdom, or do you say it's the same act that occurs in two different places?
You could put it either way, my Lord, and we could win on either basis. So on the same act point, that was, I think, essentially the concept that Lord Justice Warby was getting at in paragraph 1 of the Court of Appeal's judgment, where he said it was completely artificial to characterise the movement of the hand holding a pen and the appearance of words on a paper as not all part of the same act. And that would be the all part of the same act answer. But equally, we would be entirely content with an analysis which said, yes, there was a causative act in Bahrain, when the buttons were pressed to install the software, or when the instruction was given to turn on the microphone. But there was also an act in the United Kingdom when the recording started. Just as in the Litvinenko scenario, there would be an act in Russia when the high-ranking official decides to send individuals on that mission. And that would, on any view, be causative and highly relevant and necessary to the question of attribution.
The trouble I have is that once you accept that effects of an act I do can also be acts that I do, it's very hard to draw a line. I mean, I would prefer to analyse the writing, saying that when you refer to someone writing, you're actually referring not just to an act that they do, but to it having a consequence, as if I'm just moving my hand and nothing occurs on the page, then I'm not writing. But to say that but if you want to say that some effects of acts are still themselves acts.
Yes. And the Court of Appeal found helpful in this, and the Court may find it more helpful than hearing from me on it. The Court found helpful on this the approach taken in Levin and Ashton Investments. And it addressed those two judgments, and it didn't do so by way of saying these determine the principles which were to apply.
No.
It referred to them as showing that Bahrain's approach would be artificial and unprincipled, or illustrating that it would be artificial and unprincipled. And we get that in the Court of Appeal's judgment, beginning at paragraph 34 on page 153. I'm sure the court's seen them already, but I wonder if Your Lordship, my lady, might just cast your eye down those paragraphs from 34 through to 39, or to 40, in fact, on page 155. So 153 through to 155, because they helpfully set out the key passages in those two judgments.
The word artificial is used quite frequently.
It's
In
the other
both
way.
cases.
At the end of paragraph 35, they say why those cases are helpful.
Yes, my Lord.
Natural appropriate use of language to describe the hacking.
I mean, what it does show in your favour is that in some contexts it has been treated as part of an act when
Yes.
it has a consequence.
Yes, and
But one view of it would be that then you've really got to see what the context is.
Yes.
You've probably looked at the case that we invited you to
I'm
look
going
at.
to go to it, my Lord.
Yeah, where also in an extradition context, as it happens, there was a distinction drawn between acts and effects.
Yes.
So,
There was, my Lord, and as my Lord will recall, that case involved a very specific binary and mutually exclusive statutory regime, which is completely different to Section
it did,
5.
but it's quite hard to reconcile with your submission that the words themselves are so clear and unambiguous that they must have the meaning that
Well,
you give them, regardless of the purpose of the legislation and the context in which they're to be construed.
I'm now going to retreat into the fact that I'm on core submission 3 and I've dealt with But, and I take my lord's point, but I'll come to El Khoury in a moment, but we ultimately submit it probably doesn't assist the court in the determination of it. To the extent it's relevant, there's something that can be drawn from it from both sides. And we say it does illustrate, again, hesitate to use this word, I think it uses the word common sense.
Oh, does it? Oh, dear.
As an approach. But it's, it only goes so far. But the thrust of both Levin and Ashton investments is, and again, one's at risk of all the same vague terminology, but if one's looking at the reality of a situation, just as in Levin, the reality of the situation was that the fact that this Mr. Levin was sitting in Russia, interfering with bank accounts across the internet in the United States, didn't mean that the conduct was occurring in Russia. The conduct was held to be occurring in the United States. It's the same, different, but technological processes having their substantive effect and being treated as the conduct in consequence in the United States. Likewise, Ashton Investments, which I think gives life to the metaphor about the safe door being opened that the Court of Appeal then lights upon. That's the reality of what, on the Respondents' case, has occurred here. There has been a gross series of instances of conduct which interfere with fundamental rights in this jurisdiction.
So you say even if one switches the terminology from act or omission to conduct, it's
Yes.
exactly the same.
Exactly, my lord.
You say in this case there has been conduct
Yes.
in the UK.
Yes, and so that's my answer to my lord's point about 201 on Clark and Lindsell. The important point being that it just has to be an instance of conduct, not the all-embracing conduct.
And if we talked in terms of breach of duty, would you say the same, that the breach of duty has occurred in the UK?
The relevant cause of action here, my lord, is the
Course of conduct.
course of conduct under the statutory tort.
Yeah.
And the course of conduct has occurred in the UK on my submission as to what conduct embraces.
So the breach of duty occurs in the
Yes,
UK.
so the actionable conduct occur. You've got both breach and damage.
Would suppose the allegation of harassment was persistent telephone calls from Bahrain? Would they be occurring in contact person then be acting in this country?
On the receipt of the telephone calls.
Yes, because the voice is transmitted
Yes, I would say
electronically or probably by satellite these days and comes in the ear of the person, causing them psychiatric harm, let's suppose. Is that conduct taking place in this country?
I would submit it would be, my lord. I'll be corrected if I'm wrong over the short adjournment, but I would submit it would be. But even if it wouldn't be, we say this conduct is materially different and more obviously conduct in the UK. It's very difficult, we say, as a matter of substance, to distinguish Bahrain's conduct, as alleged in this case, from a scenario where Bahrain has sent intelligence operatives to sit outside the home of my clients and carry out surveillance. Obviously, in that latter scenario, the presence requirement, if it be one, would be satisfied. But, as a matter of substance, what Bahrain has done is the same.
In a digital age, they've extended their ability to
Exactly so,
conduct.
my lady.
Yes.
And one might say, illustrating the paranoia of all lawyers that AI has the potential to do better than the human agents. And if you're, and to go back to Dickinson, less flippant about it, if you to go back to Dickinson and that helpful illustration they provided, or encapsulation they provided in the 2025 edition, if you're deploying spyware of this sophistication, which is active and activated in the UK, you're acting in the UK. I'm going
Can I just put one further argument to you? With a draftsman trying to, just assume for the moment, replicate
Yes, my lord.
Article 11.
Yes, my lord.
At the time we're doing that, although there are clearly examples of which telephones and detonated bombs have been talked about, clearly the wording of Article 11 is, by English drafting standards, extremely convoluted. We've got references to facts, events, the author, rather an unusual phrase. Might it not be said that the draftsman is trying to replicate that by simple English words, act or omission?
It has been said.
Yeah. Yes.
Mr. Hickman,
And that therefore connotes presence.
A, my lord, it has been said. B, we say it shouldn't be said. And the reason it shouldn't be said is that it's...
You probably don't object to it being said, but you just say it's wrong.
You
We
showed
say
us.
it's wrong,
You
and
showed
if you're
us
looking for an
16
elegant
too.
formulation, a more elegant formulation, a more precise formulation of the presence requirement, it's very easy to provide. We've seen it reflected, indeed, in some of the legislation.
Unless you think it's unnecessary. Because unless you think it's unnecessary,
unless you think-
either because you think that this makes clear that human presence is required, or, insofar as there was conceivably any doubt about that, the courts are required to comply with international law and therefore would apply Article 11.
My lord, I fully understand and see the logic of the point my lord's putting to me, and we, without wishing to shortcut it too much, we do say it's wrong. We do say that in circumstances where Parliament had before it Article 11 in its right hand and Section 5 in its left hand, there is an obvious and deliberate divergence as a matter of comparison of those two documents. And it's a real stretch, we say, to say, oh, look, Section 5 is just a jolly elegant encapsulation of what's in Article 11. And if we need any illustration of that point, it comes a little bit later than the European Convention on State Immunity, but it comes in the form of the draft articles on the UN Convention that I showed the court a little time ago, where the commentator was saying, essentially, as we would have it, we need to include an express presence requirement to exclude transboundary tools. I'm going to deal, after the short adjournment, if I may, with El Khoury, and then I'll hand over to Professor Webb and Mr. Silverstone. We're well on track in terms of timing.
Good. Thank you very much. We'll rise now. We'll sit again at 2 o'clock. Thank you all very much.